distinguished role this morning of getting to provide you with administrative announcements. So please silence all cell phones and other devices. Please be aware that if you leave the Constitution Center building for any reason, you will have to go back through the security screening. Most of you have received a lanyard with a plastic FTC event security badge. We reuse them, so please return them on your way out. If an emergency occurs that requires you to leave the conference center but remain in the building, please follow the instructions provided over the building's PA system. If an emergency requires evacuation, an alarm will sound. Everyone should leave the building in an orderly manner through the main 7th Street exit. After leaving the building, you'll turn down 7th Street, cross East Street to the FTC Emergency Assembly area. You'll remain in that area until instructed to return to the building. If you notice any suspicious activity, please alert building security. Please take your seats rather than standing. Actions that interfere or attempt to interfere with this event are not permitted. Anyone engaging in such behavior will be asked to leave, and anyone who refuses to leave voluntarily will be escorted from the building. Question cards are available from staff or from the information table in the hallway. Staff will be available to collect your cards. Please raise your hand to alert them. FTC commissioners and staff cannot accept documents during the event. Any documents provided are not part of the official record and will not be considered as such by the Commission. This event is to be photographed, webcast, and recorded. By participating, you agree that your image and anything that you say or submit may be posted indefinitely at ftc.gov, on regulations.gov, or on one of the Commission's publicly available social media sites. The webcast recordings and transcripts of the hearing will be available on the FTC's website shortly after the hearing concludes. And finally, restrooms are located in the hallway just outside the auditorium. We have today, I think, a very exciting agenda. This morning, we will be talking about the role of notice and choice, and then another panel on the role of access, correction, and deletion. This afternoon, we'll be hearing some remarks from Commissioner Rebecca Kelly-Slaughter. Then panelists will discuss accountability, and a two-part panel will tackle the big topic of whether the FTC's current toolkit is adequate. And with that, it's my pleasure to turn it over to Peter McGee and Ryan Meem, who will be moderating our first panel of the day on the role of notice and choice. Thank you.
Well, good morning. My name is Ryan Meem, and I'm joined by my co-moderator, Peter McGee. We work in the FTC's Division of Privacy and Identity Protection. This panel, as Elisa just mentioned, is focused on the privacy principles commonly referred to as notice and choice. We're delighted to have with us this morning 6 panelists and experts who've spent a lot of time thinking about this issue. To our left is Jordan Crenshaw, Policy Counsel at the U.S. Chamber of Commerce, Pam Dixon, Founder and Executive Director of the World Privacy Forum, Florencia Murata-Wergler, Professor of Law at New York University School of Law, Neil Richards, Professor of Law at Washington University in St. Louis School of Law, Catherine Tassi, Deputy General Counsel, Privacy and Product at SNAP, and Rachel Welch, Senior Vice President, Policy and External Affairs at Charter Communications. I want to thank our panelists for participating today, especially so early in the morning. I also want to thank all of you here in the room and those following online. And for those here in the room, again, as Elisa just mentioned, if you have a question, please raise your hand. FTC staff will bring around a question card for you to write your question on, and someone will bring that up to us to take a look at. So with that, I'm going to start with some questions that are intended to lay the groundwork for our discussion this morning. The Fair Information Practice Principles, or FIPS, have been around for decades. While all of the principles have their place, in some respects, notice and choice are often the starting point when we talk about consumer privacy. So I want to start with a baseline question this morning. When we refer to notice and choice in the privacy context, what do we mean? Do I have a taker?
I'll start off. I mean, I think in terms of notice and choice, I think two things come to mind. The first is certainty, in that consumers and business have certainty about how data is used and how data is shared and how data is collected. So that there's no ambiguity in terms of what companies or what holders of data are doing. And the second is control, putting the consumer in the driver's seat with regard to how data is shared, how data is whether it's retained by a company as well too. So when you have those together, you create a balance in which companies and consumers are in fact able to have certainty and able to know the rules of the road as they go forward.
Great. Thanks, Jordan. Let me ask if any other panelist wants to add something to what Jordan just said. Okay, well, let me go then to these two concepts, notice and choice, are often linked together, but are they different? And Pam, you want to take that one?
Yes, and thank you. Thank you to the FTC for inviting me here today. I really appreciate the opportunity to talk about these important issues. You know, notice and choice has a lot of different meanings depending on who you ask and what jurisdiction they live in. So it's a very difficult question to answer. So a lot of it depends on your jurisdiction. But speaking broadly about the U.S. jurisdiction, notice, when I think of notice, I really think of the Privacy Act and those laws. And I really like to think of notice as something that's meaningful and robust. In regards to choice, I don't view it as individual control. And the reason I don't view it as individual control is because, okay, so in a paper world, when some of these terms were conceived of, in a paper world, I do think that you could apply certain mechanisms and have more control of your data. There was this lovely term of privacy by obscurity. You know, if you're dealing with a room full of paper, certainly you can have privacy by obscurity. It's really difficult to get to all that paper all the time. But when you're dealing in a digital ecosystem of some complexity, we cannot fool ourselves that we have control, individual control of our information. So for me, when I think of notice and choice, I think of a paradigm that no longer fits the reality on the ground. And I do think that that is one of the reasons that a lot of the privacy tensions have arisen today. So one of the things about notice and choice is that that system tends to push decisions toward the end of the process, not toward the beginning of the process. And that's a problem. So for me, personally, I'd rather have notice, love notice, but I also want a seat at the table when the notices are being decided upon and written. And I really don't want to have a choice that is a checkbox at the end of a process. And I think that's the real downside of what is often referred to as notice and choice. I do think there are alternatives that are very powerful, and we'll get to those later, I hope.
Yes, we will. Let me ask if anyone else has an additional thought on this topic. Go ahead, Catherine.
Just one final thought from me. I think, as we'll probably find as we go further in this panel, that notice and choice don't always go together. You could have notice without choice and choice without notice. And so just to add a little bit of nuance to the concept of choice, that it doesn't always mean one thing. Choice can be control. It can mean opt-in. It can mean opt-out. You can choose between one thing and another thing, and any of these might be the right kind of choice depending on what the context is, depending on what type of data we're talking about or what type of processing is happening. And so the notion of choice as a flexible principle, I think, is really important, and also that every type of choice has an actual impact on the organization that is offering the choice. Choices have engineering impact. They have operational impact, and so allowing flexibility in what the choice is that an organization offers, depending on the type of data and the type of processing, I think is important when thinking about memorializing the principle of choice in, for example, legislation.
Great, thank you. Anil.
So I think before we get too deep into the technicalities of notice and choice and opt-in, it's worth looking at the big picture here. I think Ryan very helpfully started us off by talking about the fair information practice principles, right? And those were designed, as Pam mentions, for a paper world, or maybe a world of paper and tape. Right, so those computers with the big reel-to-reel spools that we see in the old photographs, that is the world, a world in which there was not very much data collection, a world in which the people who came up with the notice of the idea of the Phipps, I'm thinking here like Alan Weston in Privacy and Freedom in the late 60s, or Willis Ware, who chaired the report of the Department of Health, Education and Welfare in 1973, which gave birth to the Phipps. We're trying to manage a real fear of a world in which everything people do is tracked and collected and monitored, and in which people have really very little knowledge of what is going on and very little ability to affect the way information about them is collected, used, disclosed, stored, breached, and otherwise processed. Notice and choice have been a distillation, a boiling down, I would say a weakening of those principles. And so we have the situation that we have today. If you asked Willis Ware, if you asked young Alan Weston, what the Phipps would have done, I think the Phipps, for the purposes of forestalling that world that the people of the late 1960s, early 70s feared desperately, the Phipps have been a spectacular failure, and notice and choice have been a spectacular failure, which is not to say that notice and choice have no place in a consumer protection regime for the 21st century, but I think it's important to look at the evolution of these principles and to look at what they were trying to do and how they failed to do that. If we want to look broadly and critically and intellectually honestly at the series of really complicated and nuanced and difficult issues of competition and consumer protection we face today.
Can I have
Florencia.
a quick follow-up to Neil's point? In addition to that, there's the added complexity of the information going through several layers and several parties through particular chains. So when we think about notice and choice, we also need to think about, to the extent that we might think that the model is somewhat feasible in some respects, and we can talk about that later, and the need, as Catherine said, for some type of flexibility, which might be necessary in some cases. So notice and choice might be only operable within a particular domain when you have a consumer or a user facing a particular firm. The issue that arises is that even when we talk about the Internet of Things, or when we talk about subsequent transfers of data, is that it becomes increasingly complex and almost impossible to extend the model to the current ecosystem in which information transfers and it's used about us. That doesn't mean that we don't need, or that the market doesn't need the type of flexibility that notice and choice affords. So it's a complex question. It would be a lot easier to say, well, you know what, clearly it's not working, let's scrap it, but it has some important benefits. So the question is, how do we distill those benefits while taking into account the particular problems that arise from, first of all, the structure in which tons of information about us get gathered and in ways that are impossible to track and notify consumers, but also if we think about consumers' limitation and really we think in a more wholesale manner the relative effectiveness of disclosure regimes in every single context that you want to think of in the area of consumer protection.
Thanks. And Pam, I know you wanted to add a thought.
Yes, I so appreciate both of your comments. There has been, FIPS were Willis-Ware, for anyone who has not read the HEW report, Willis-Ware could see around corners. He had just an extraordinary mind, and it's worth reading that original report. But one of the authors of the report, who was deeply involved in it, is still alive. And her opinion is that people deeply misinterpreted the FIPS. And the authors of HEW report intentionally threw individual control under the bus. FIPS was never meant to be a regime of, for example, notice and control. That's not what it was about. So I do think, to Neil's point, there's been some rather profound misinterpretation of FIPS. And we have to understand that it's not a regime that you're supposed to be using for controlling data. They understood even back then that controlling data at an individual level was a fool's errand and would not be feasible going forward into the future.
Rachel.
Well, we maybe come at this with a slightly different approach coming from a company's perspective, and we actually believe that notice and consent and choice are actually important parts of the process, and that they're deeply interrelated, that consumers need to have transparency about what companies are doing, about what their interactions are with the company that they're contracting with or engaging with online. And from our perspective, we see that there's growing consensus that there's a need for a federal framework, that we've tried to do this through self-regulatory principles. We've tried to do this through kind of trial and error. And it seems as though across the ecosystem, there is a growing consensus, and across civil society and regulators, there's a growing consensus that we need to reduce this to paper and have there be strong guidelines that people follow in terms of how they interact with their consumers. And a little bit, I feel like some of the conversation about we're maybe in a post-notice and consent world is giving up before we tried. So Charter's put forward 5 principles that we think should undergird any U.S. privacy framework, and those include transparency and choice. For us, we actually think that having more stringent rules about an opt-in consent, where the consumers all start with kind of a blank slate. They get to start with 0 and engage with the company and decide, do I trust you? Do I have confidence in this process? Do I want to engage with you to take this service and to trust you with my information? And so we think an opt-in approach really gives consumers a lot of control over how they engage with the companies, and it's a good starting place. There may be opportunities where you need some limited exceptions, but we think having broad and ambiguous exceptions actually undermines that confidence that we're hoping to see encouraged through a U.S. privacy law. And I think we've seen with Europe, with other countries, with California engaging in this, that there's a real desire to have some kind of clear rules of the road. They may not be perfect, the world is complex, but it doesn't mean we throw up our hands and give up before we try.
Right. So I have a follow-up question. We've heard a lot already this morning about this idea of choice and very different viewpoints about whether it's working and control, offering different choices to consumers. So when we talk about choice, what do we mean? So should consumers get to choose whether to allow collection of their data at all? Or do we really mean that consumers should only have a choice regarding how a collector uses that data once it's collected? And I realize, things are very context dependent, and we've heard about that different situations may merit different answers, but I'm wondering if anyone has a thought about this. Pam.
Thank you so much. So if there are many different solutions that exist to cope with many different problems, I don't think we should have one silver bullet that we think of for looking at privacy issues. This includes, one federal bill. It's not going to solve everything. It can't, because of the complexity of our data ecosystems, which overlap with tremendous, tremendous complexity. So if you look at if you really go to a basic layer of understanding how the regulatory process works, you really have three models to choose from. You can look at a centralized structure, such as command and control legislation. That's what I think a lot of people were talking about yesterday with the GDPR and CCPA. Those are centralized structures. People also talked yesterday about privatization, paying for data and other, data is property. That's a different model. And then there is a third way that I really didn't hear anyone talk about yesterday, which is self-governance. So the Nobel laureate Elinor Ostrom spent 40 years of her life doing empirical research on self-governing ecosystems that were enormously complex and figuring out what allowed them to thrive by being self-organized. And she came up with 8 principles. And those principles, I wrote a paper, I presented it at Harvard's Kennedy School on digital identity ecosystem, and I laid out how the Ostrom principles work in very, very complex ecosystems. There's a role for command and control. Should we have breach notification? Yes, thou shalt, right? There's a role for privatization. When victims, extreme victims of domestic violence need a Social Security number change, they have the ability to do so with their data. But in enormously complex ecosystems, data brokers are one such ecosystem, identity ecosystems are one such type of ecosystem. There is often a need for something that is more granular, that allows a closer fit to these very distinct and difficult models. So today we actually released a discussion draft. It's called the Consumer Privacy and Data Security Standards Act of 2019, and it discusses how to do voluntary consensus standards, but with due process. And this is already actually written into law in the US, and the FDA has been using this for medical devices for at least 20 years. So we know it works for very complex issues, and I think that that's a way forward that would be very powerful and work.
Okay, let me ask if anyone has something that they want to add. Okay, let me move on to another question for our panelists. Are there some practices for which only notice is needed and no choice?
I have a comment. Okay.
Pam?
Please, someone, you've got to step in and save
yes.
me. All right.
So, you want to go first, Pam?
I have a quick comment. If you look, I think that there is room, because of the complexity of data, I do think that there are some uncontested uses of data. For example, fraud analysis. I think we can agree that that is an uncontested use. Can there be potentially an agreement made perhaps through these standards processes with due process, openness and transparency? Can there be a general agreement amongst all the stakeholders that have an interest in the data that some uses can be routine and can be allowable without consent, such as fraud, et cetera, decided upon by the stakeholders? And then anything, and they decide the boundaries of what exists outside of that. Something that is more meaningful would need, for example, meaningful consent. But I think the stakeholders who are party to that should have a say in that. Not a checkbox, but a seat at the table.
Yeah, just a quick point to add to that. So here, context and expectations matter a lot, and understanding what consumers expect and know might be something that we need to do some more research on. I mean, hopefully, whatever comes out of this will be based on a systematic analysis of the market and what consumers want and what they expect, because many times just like when we go to a supermarket and we expect certain things, over time we become relatively savvy or sometimes relatively not savvy. And so the extent to which there are the data collection and use are consistent with the expectations and the needs of the business, there seems to be very little need to require choice. Also, when we think about how consumers get tired of making decisions on a constant basis, remember that 1 week where we all had to close those GDPR pop-ups? It just becomes meaningless. So one thing to keep in mind is how whenever we think about a system, whenever it gets adopted, how it will look on a systematic way. Are we going to be bombarded with choices in a way that makes innovation difficult and also decision-making difficult? So it would be important to distill those types of decisions that might need some either additional education or information to correct misperceptions, and also those that are outside the scope of the context of which consumers expect to share information. So when you give your credit card information to process something, you expect that this information will be shared with a third-party payment processor. You might not expect that then that information will be sold to a post-transaction marketer or something like that. So we need to think about context, but also how this affects consumers, not only consumer decision-making in general and how meaningful that is, but also how it affects the experience that we have and the ability of these highly innovative markets to continue to evolve in a way that is respectful of consumers' expectations.
No, and I'll echo that as well, too, in terms of there are some contexts in which notice and choice are not necessary. And I think when you're looking at consumer expectations, as has been said before, and the context of the transaction that you're making with the consumer as a business, for example, clearly mapping software requires the use of geolocation data, for example. So that's an example of clearly inherently you have to use data to provide the service that you're giving to your customer. Other examples are public policy examples as well too. Anti-money laundering, prevention of shoplifting, for example, security, trying to use data to prevent malicious activity and comply with other legal obligations. So there is a space in which some data should not be subject to notice and choice, given the fact that it's either necessary for the transaction or there are public policy reasons behind it.
I think it's really important when we talk about notice and choice, though, to be specific about what we mean. The question that Ryan originally asked was whether there are situations where notice but not choice. Was it notice without choice or choice without notice, or both? Are you interested?
Notice only.
It was notice only, right? In which there is notice but no meaningful choice or no choice. You could describe the entire internet ecosystem in the United States up to this point as falling under that model, right? Particularly surveillance-based advertising, particularly a lot of activity of data brokers. What has practically happened is there's been notice, and it's often been fictive notice, constructive notice that is buried in either privacy policies that are either too vague to tell consumers anything, or too specific for the average consumer to be able to rationally comprehend. And in any event, as Florencia points out, the sheer scale and scope of the numbers of such notices are more than a privacy expert or a privacy counsel can comprehend in the aggregate, acting as a consumer, much less our average consumer for whom we want to target these laws. So I think it's important to, rather than we need to be critical about our use of the terms notice and choice, because very often we talk about them as if notice is meaningful and consent is real, rather than notice being constructive and consent being fictional. And the model with which we construct these rules has to take into account, as Florencia points out very eloquently, the actual context in which they're deployed and the bounded rationality of all consumers.
And I would just add that, I think that there are, maybe we come at it from a slightly different perspective, that while we agree that there should be some limited exceptions to consent, that when people talk about context, I'm not sure I really know what it means. So when Jordan was talking about some of the enumerated exceptions, so interacting with legal process, preventing fraud, potentially improving your service, rendering the actual service that the consumer has requested, whether it's the sale of a product or the purchase of broadband service. But when you get into trying to add ambiguous concepts like context that maybe the consumer doesn't understand, the business may be substituting its judgment for the consumer's judgment, and that can result in consumer confusion, it can reduce trust, and we worry that the exception can swallow the rule. We might prefer an approach like the GDPR approach where they have legal bases for processing, but but those are limited and bounded. And then I think that helps to educate the consumer to ensure that their notice is more than constructive and that their choice is more than fictional, and that is what companies are looking to do, because at the end of the day, we're hoping that we can sell services, that consumers will come back to us again and again and trust us, that we're going to treat their relationship with us with respect, that their data is going to be treated with respect by us. But if we create a system where there are broad exceptions to the concept of choice, I think that leaves them feeling limited in their ability to direct how their data is used and how they engage with businesses.
The problem, I respect that. I think the importance of trust is really essential to this whole process, which I think we're going to talk about later. Yeah. And I don't want to foreshadow. I do think, though, that the difficulty is that consent of that sort, sort of what we might call gold standard consent, informed consent, does not scale. We can only make a certain, as human beings in our minds, we can only make a certain number of rational, conscious, thoughtful choices in a given day, and the sheer number, the scale and scope and technical and legal complexity of these sorts of agreements, even with the very best intentions of lawyers and engineers, and improvements of interfaces and privacy dashboards, is just far too much for the average consumer to comprehend.
Just to add, can I jump in? Oh, okay. So I want to respond to Rachel's concerns, and I think your concerns are legitimate, and we have to take those concerns into account. So in thinking about those concerns, I think that one of the things that we have to understand, and I agree with you, Rachel, in regards to broad exemptions. I think it is very, very dangerous to create standards from rhetoric or from metaphor, either. Either one is very dangerous. History teaches us this over and over again. We need to have data-driven decisions. In order to get data-driven decisions, I do really support a voluntary consensus standards process that allows for granularity. So, for example, for your business model, you could hold a stakeholder process that could articulate the consumer concerns at the table so that they help articulate what they make choices about in the first place. So it moves the decision-making into a place where not only are consumers having genuine decision-making ability, they have a seat at the table and they can assist in outlining what their concerns are at the very beginning of the process. And I think this is very powerful and very meaningful when it's done with due process, with fairness involved. But I think that waiting until the end of the process and giving consumers a whole bunch of checkboxes is not powerful. And I think we need to get away from that model. And to the points that Florencia has been making, I think it's very important to understand that it is not possible at this point in data complexity to have one model that just fits absolutely everything. We need a multiplicity of solutions to attach to a variety of problems and challenges in privacy.
Just a quick follow-up to Neil and Pam. And so in terms of, so I agree that data-driven decision-making is important, and I also agree that that notice, that consent at this point, real, actual consent, is for the most part a fiction. So I have some data on that. So I've been working on whether consumers read contracts, and I have, so it turns out that about, when you look at consumers in real settings, it's only about 1 in 1,000 that access these very saliently described or displayed contracts that you have to click on I agree. Not that many actually bother to figure out what it is that they click on. Maybe there's more hope in simplified notices, but it's also true, and research also shows that consumers systematically misperceive and misunderstand certain things, not everything. That's why more research and understanding, and Rachel is right, that context is such a malleable thing, and you can have an exception swallowing the rule, but that doesn't mean that we can't find out what those are. I mean, we do it in other contexts, in deceptive advertising or in trademark confusion. So why not have a more of a data-driven approach here? And also, these privacy notices have been growing and growing and growing exponentially over the years, and they require a graduate degree to understand.
So
Catherine, last word, and then we're going to segue over to Peter, who has some questions about pros and cons of the existing models.
Okay, I was just going to say that I don't think notice and choice don't operate effectively. I think that so at Snap we use a couple of different models
Did you say you don't think they don't?
Yes,
I don't think they do.
I don't think that notice and choice don't operate effectively. I think they do in certain contexts. Sorry, three negatives. At Snap, we use about 3 different models to be able to provide effective privacy protections to our consumers. And we think that notice and choice operate effectively as privacy protections in certain circumstances that include, for example, when the product or feature that we're providing notice and choice about is not complicated, that we're able to provide just-in-time notice and choice, usually within the context of providing the product or feature to the individual right at that moment. When the product or feature isn't collecting very much data or isn't using very much data, that it's not sensitive data, when the choice can be presented simply and exercised simply right there and then in the moment, when the choice is meaningful to the individual in that moment, and when the Snapchatter isn't given so many choices that it's confusing and rendered meaningless. We combine notice and choice with privacy by design. We build privacy into the design of our products and features. And this is really critical to balancing with notice and choice as a privacy protection, because there are many types of privacy and data processing that you want to take out of the hands of consumers and just build the privacy protection into the design of the product. Things that you shouldn't burden the consumer with having to make choices about. So, for example, we build specific data retention periods into all the data that we collect and process. That's not a decision that we leave to our individuals, even though we give them choices to simply delete the data even sooner than when we might delete it. So we think the combination of building privacy into the design of products and features balanced with sensible decisions about choices about products and features that individuals are using in the moment is the right balance. In addition, we've found it really, really useful to do legitimate interest assessments related to other data processing in the GDPR context, and that kind of speaks to giving notice and no choice. When you do that balancing assessment, it requires you to think about the privacy interests of the individuals, and if you land on legitimate interests as your lawful basis for processing, you can really only do that if your business interests outweighs the privacy interests of the individual, and that balancing can only come down in your favor if you've given enough privacy protections to the individual. So we found that to be kind of a third way of giving privacy protection to individuals. So the 3 combined, I think, can provide adequate privacy protection.
Great. Thanks, Catherine. Peter now has a question for the panel.
Sure. I'm going to actually follow up with something, Rachel. You mentioned that Charter's supporting federal privacy legislation with an opt-in approach, and I'm just wondering why opt-in is preferable to an opt-out approach from your perspective.
Thank you. So from our perspective, and as I said earlier, that we believe that an opt-in approach really helps engage the consumer. And I understand that there is some research, but I think there's research on both sides that consumers, they have said in surveys that they want to engage, that they want information. At the same time, the consumer then maybe doesn't take the information. But if every consumer is starting from the same place, that nothing is being collected from them, nothing is being processed from them, then they have the opportunity to really engage and make a decision. And we think it should be meaningful. I don't know what the silver bullet is in terms of meaningful, but we certainly would say no pre-ticked boxes. It has to be renewed with reasonable frequency. It needs to be renewed when there's a new practice that it wasn't first provided to the company for. So we think that at the same time that technology creates complexity, it also creates new tools to engage with the consumer. So as Catherine said, pop-ups in the process of engaging with the service or the product. There can be just-in-time notice. But we also see with the privacy policy, and I'm not going to be the one who sits here and defends it as the perfect answer, but it certainly forces a company to sit down, take an inventory of what we're doing, think about it. It requires us to do a gut check about, does this make sense? If this were printed on the front page of the New York Times, would we be proud of this practice? It also enables academics to look at the privacy policy to say, this makes no sense, or this looks misleading, and to call us to account for that. It also enables regulators to look carefully at it and make sure that we're acting in compliance with that. So, and I think what we've seen with the various breaches and misuses and mishandling of data over the last year to 18 months is there's been a new ability to educate the consumer, to help them understand. So we really believe in the consumer, that they are intelligent, that they understand what their preferences are, and that consumers really differ in their preferences. So if you have an opt-in, they have ability to determine my preference today, because I woke up on the wrong side of the bed, is I don't want to share anything with anyone. Tomorrow, I may change my mind. Whereas with an opt-out, then the burden is on the consumer. They have to go and figure out, what is Snap's process? What is Charter's process? How do I opt out? Where do I go to do it? Whereas an opt-in is brought to them and they get to make the choice on the front end.
Well, just to play the devil's advocate, and then I'll open it up to the rest to weigh in, but you said that in opt-out, you're putting a big burden on the consumer, but in a purely opt-in world, isn't there also a pretty heavy burden on the consumer to make choice after choice and possibly just throw their hands up in frustration and opt into everything just as a default?
Well, I think that's always the balance, right? It's the balance for us in creating our privacy policies. How do you make it simple and clear enough, at the same time balancing the need for comprehensive disclosures? And with regard to a consent model, it's the same thing. We're always looking for the Goldilocks, and we certainly are open to the ideas of enumerated exceptions. There may be ways to enumerate prohibited practices as well, but we think we should start from kind of a core set of there's a vast middle where we think the consumer should be engaging, and that there's ways that we can do this so that it doesn't result in fatigue, and it really helps the consumer to engage.
Anyone want to weigh in on this?
So
Neil, looked like you were going to say something.
I would absolutely agree with you, Rachel, about the virtues of long-form privacy policy. And I know Mike Hinsey is going to speak about this in the next panel. Long-form privacy policies do have those virtues, but they do not inform the consumer. And if our goal is to inform consumers to enhance choice, to enhance meaningful consent, long-form privacy policies have their virtues, but those are not the virtues that they have. I'm sympathetic to the idea of empowering consumers, empowering the users of technology. I think the context, though, unfortunately, does matter. So I, for example, am a customer of both Charter and Snap. And if I'm using Snapchat, I think in those contexts, good privacy engineering, good cues might help me not share the image I want to share with the wrong person. And I think that is good engineering, and that is empowering choice. And it helps because I'm thinking about it. But ultimately, I don't really want to engage with my cable company. I don't want to engage with my search engine and with my first social network or my second social network or my third social network. I don't want to engage with the equipment manufacturer of my smartphone and the service provider of my smartphone, who may be different from my cable company. The problem is that kind of engagement on data processing practices just does not scale. Woody Hartzog at Northeastern University and I have an article which we're about to publish in the Washington University Law Review called The Pathologies of Consent. And we catalog many of the problems with consent models in American law, particularly in the digital services context. But we conclude not that consent, not that opt-in choice, not that empowered consumers are a bad thing, but that they don't scale and that they're limited. And I think 3 principles need to happen for that kind of consent, that kind of choice to be effective. First, choice has to be infrequent. We cannot have that kind of engagement with all of the various companies we have relationships with any more than we can memorize all of the passwords we have with all of those companies. A separate but related problem with similar implications for the limits of consumer cognition. Second, the consequences must be clear. If I send a picture I meant to send to my wife on Snapchat, to my daughter on Snapchat, or they're not my friends, but to my students on Snapchat, the consequences of that choice would be clear. But the consequences of opt-in processing to target online behavioral advertising to provide more relevant goods and services, don't you want that? Just does not work for consumers. The consequences there are not clear, the legal terms are not clear, the technologies are not clear, and the risks are not clear. And third, choice has to be meaningful. There have to be meaningful alternatives to the data practices, and take it or leave it, accept all of our terms or don't use Amazon or don't use whatever service it is, simply cannot work. So choices have to be infrequent, the consequences have to be clear, and choices have to be meaningful. There have to be real alternatives.
Just to jump in, thank you. There's a couple of thoughts I have. The first, I want to respond to Rachel, or to the comments. One issue that came up in discussion here was the issue of data mapping, how privacy notices afford a company the opportunity to map their data. We've seen in Sarbanes-Oxley and even in proving compliance technically under GDPR how useful data mapping can be for a company. It's also useful for any kind of process in discussing options directly with consumers. And for me, when we put a credit card to a vendor to make a payment, there is a standard that controls how that happens. When data is de-identified under HIPAA, there's a standard that controls how that's happened. There are certain instances, in fact, many instances in privacy, in the interface between consumers and their data and companies, where there are tough privacy problems that edge on all of these consent issues, which are known and well understood issues at this point. So why not ask the consumers in a formal, open, transparent, voluntary process that includes principles that comport with due process? Why not ask them what they think and help establish the standards with all the stakeholders at the table? And then consent is contextualized for that specific business model and/or business and/or sector, depending on what the problem is to be addressed. I think we have to be careful. There are, again, I'm just going to go back to the models. We've got a centralized model, we've got a privatized model, and then we've got more of a self-governance model. And these are 3 different tools that we can use in overlap and in varying situations for really tough problems where there's going to be an over-reliance on consent. Ask the consumers. Have a multi-stakeholder process that's more formal and figure out the answers. It'll take more time, but it can be more useful than ending up with huge volumes of decisioning at the end of the process that consumers may find either not meaningful or overly burdensome.
Florencia?
One additional thought to build up on what's been said is that we might want to distinguish between what consumers say in surveys or when they ask us. We usually present to ourselves the best versions of ourselves, like I should do this and I should do that. And then when we act quite differently, hence this privacy paradox, right? Everybody says they care, but they act as if they don't, at least in some context. So to the extent that we want to understand this better, and to the extent that we want to offer only infrequent, simple choices. Some choices are just not simple at all. Sometimes consumers don't want to make choices, or sometimes they don't want to make them whole scale, is to also observe, given that we can add a little bit, is the extent to which there's inconsistencies between beliefs and actual practices, because this is doable. This is not something that is not feasible. And in that way, inform the particular recommendations that Rachel and Catherine were talking about.
Great. Jordan, I want to get you in on the conversation a little bit more. Could you talk about how notice and choice would operate in the chamber supporting a privacy bill right now?
Yeah, sure thing. So earlier last year, the U.S. Chamber of Commerce really saw that the writing was on the wall that a state patchwork was emerging, starting with California and now with Washington State. And as I talked about certainty and control earlier today, one of the things that we wanted to make sure was there was certainty with regard to regulation, with regard to data. For example, I think it's going to actually dilute notice if you begin to get notices from different states on your rights under that current regime under a different state approach. I mean, if I end up seeing those exceptions or those extra state notice requirements, I'm more than likely to probably ignore those with notice fatigue. But what we did was we brought together over 200 companies from all different sectors, all different sizes, to try to come up with consensus privacy legislation. We actually came out with text on this topic. And basically what our bill is, it is a notice and choice bill. First of all, it takes into account that there are brick and mortar businesses out there. It takes into account that there are online businesses out there, and context is definitely important as we created these principles that we developed and also the model legislation that we put forward. And first of all, our bill would require companies to essentially post a privacy policy that is clear and conspicuous, those that are covered by our act. The second would be that if you don't find that necessarily to be adequate as a consumer, you can go to the company, and the company is then required to inform the consumer about how the data about them is collected, how it's used, and how it's shared, and the business purpose for the use of that data. And thirdly, our data request that a consumer could do for a company, the company would then also have to say the type of entities that they're sharing that data with. So that way the consumer is on notice to begin exercising control rights under the Act. So the second piece is control. The first control element we give is a right to opt out of data sharing. Now, California, for example, actually has a right to opt out of the sale of data. The definition out there is a little bit squishy in terms of what that means. We felt that it was easier and gave more clarity and certainty to say that this was a sharing bill with regard to opt-out rights. And then if that's not enough, what we did is we also gave consumers control and the ability to have data about them be deleted by companies. And we wanted to make sure that if you're concerned about the use of data, if you can direct a company to delete that data, that begins to take care of that issue as well, too.
Great. So, but if I'm understanding you correctly, there's no opt-out right to prevent a first party from collecting your data in the first instance. You would actually have to reach out to that company and say, delete it.
You would either have to say delete, or you could opt out of the sharing of that data with third parties.
The sharing, but not the collection by a first party.
Not the collection itself, no.
Okay. I mean, again, that we seem to keep coming back to different iterations of this burden on the consumer. In the pure opt-in regime, the consumer's faced with choice after choice. In something like that, the consumer then has to actively find out what companies have collected information about them and seek to have that deleted.
No, I agree that a lot of these different approaches are going to have to put some burden on consumers to act if they so choose to exercise privacy rights. But at the same time, we do have to recognize that there is a balance out there with regard to the use of data, and that consumers benefit greatly from the use of data as well too. So I think as Rachel mentioned too, we have to find that Goldilocks, that sweet spot in terms of what is the right balance in terms of opt-out and also data deletion and other uses. But at the same time, we have to remember too that consumers are benefiting greatly from the use of data, whether it be from potential new safety and things like autonomous vehicles to whether or not we're able to expand lines of credit to people who were marginalized before and using new data points. So I think we do need to make sure that we also are looking at the benefits of the uses of data in light of also the regulations and the burden that may be on consumers to exercise their privacy right.
Yeah, and I didn't want to downplay there are tremendous benefits to consumers from services they receive based on data collection. I'm sorry, Pam?
Yes, thank you. Well, Jordan, I agree with you. I do think there are tremendous benefits to data use, and we need to preserve data uses because, and you mentioned autonomous vehicles. So I just finished a very lengthy process with the OECD. We have, the OECD has approved the first soft law global truly consensus guidelines on artificial intelligence. And something that was very apparent during the expert discussions of these guidelines is that machine learning absolutely, which is a part of AI, absolutely changes the ballgame in regards to privacy. When we shop at a retail outlet of whatever sort, and we use either a credit or a debit card, I think all of us in this room and perhaps watching understand that that information is extraordinarily useful and valuable. There's a gentleman in California that does a profound number of lawsuits under the Beverly Song Act, and that is when a retailer collects zip code, which is not allowable in California because it creates so much robust data about an individual. But something that no one has talked about yet is knowledge creation. So if you look at machine learning and all the data that goes into it, yes, maybe our credit card or retail purchase history is input into a data model, a machine learning model. But what gets output is new information. It's created knowledge. And that is not something you get to opt out of or take back or withdraw consent for. It's new. So that information is relevant to the consumer to whom it refers. They have a stake in that information. But so does the company that went through that machine learning process to create it. That is a common resource. No one gets to own it. It is a common pool resource. It's shared. What on earth do you do with that? That is why we've proposed a voluntary consensus standards process to deal with some of these very, very difficult problems where there are not easy answers. I think that sometimes you can have a simple model, but especially when AI gets involved, the models and the new knowledge, it is very difficult to articulate a single frame of reference or a philosophical basis for understanding how to do privacy at that level. Now, in the GDPR, essentially, AI is deeply diminished, right? And that becomes a deep question about, okay, what are you going to do about the countries that don't have a diminished capacity for doing AI? What do you do with that? What kind of outcomes do we want to see? These are serious questions, and there are not easy, simplistic answers here.
And I would say that one of the easiest simplistic answers, unfortunately, at the risk of disagreeing with Jordan, is the Chamber's bill. I understand, I guess we're talking about Goldilocks and bowls of porridge, and whether they're too hot or too cold. As I understand it, clear and conspicuous privacy policies, duty to inform, disclosure of data sharing practices, opt-out of data sharing but not collection, and control over deletion is a bowl of porridge that is so cold it is stale. That I think the reason we got into this mess, I think that the Chamber's bill doubles down on the spectacular failure of the FIPS, which has led to this hearing, which has led to hearings on the House, which has led to hearings at the Senate. It's led to Cambridge Analytica. It's led to data breaches, that this is just insufficient, and we need to have a better way than merely doubling down on the existing pathologies of notice and choice.
Just to add some hard data to that, So a systematic analysis of privacy policies that I've conducted over time, like first measured from the beginning of 2009, taking weekly snapshots of privacy policies till 2014, and then finally now in 2018, what you can see is that privacy policies have grown from about 1,300, an average of 1,300 words, to almost 3,000, and they just continue to grow. So there is more detail. The 2012 FTC guidelines recommending layered or short notices have not been taken up. Actually, there's a really interesting recent study that also measures the extent to which the plain and simple directive of GDPR has been followed, and the authors found that it hasn't at all. And in fact, when you look at readability scores, both in US and the EU, it requires about 15 years of education, and the reading level, basically the type of reading level that you see is a type of article that you would read, not a law review article, it has 1 million footnotes, but an article in a scientific journal. So that makes it's great for, it's a great way of showing commitment by a firm. It's a great way for regulators and others to hold companies accountable. I mean, assuming that damages problems can be fixed, since many cases just get thrown out. And it's great for me because I study them and I've been studying them for years. But they're not the way to interact with consumers, and that's why this idea of maybe short, just-in-time notices, ways of meaningful, not that many choices when it matters, and this idea again, the collection of information and what we do with it and firms do with it is extremely valuable, and we don't want to, a lot of people in the GDPR regulators are extremely, or EU regulators adopting GDPR are extremely concerned by what it's going to do to innovation. This is not a bill or a law without costs. Mm-hmm. And this is something that we need to keep in mind, because consumers benefit greatly from this, but they can get hurt in many different ways and in ways that they cannot track. So choice, when you can't understand, as Neil said earlier, you can't understand the consequences of that choice, becomes very difficult. So, amping up privacy policies, which is basically the weakest point of notice and choice, seems to me a misdirection, or more than anything, a missed opportunity.
Yeah, I'd just like to respond to Neil's,
Sure.
Neil's comment about the chamber bill. I mean, we're talking about porridge. I mean, I think that, this is a first crack at the business community looking at this issue. I mean, we've gone from an era of self-regulation to an era of really calling for meaningful privacy protections. I mean, if you view it as cold in terms of porridge, it's better than no porridge at all, not to feed anyone. I mean, what I would say is that this is a step that we're taking, and I think that we are continuing in the business community to look at other options and other ways to address consumer privacy. But at the same time, too, we have to look at the tools that the FTC has in terms of what it actually statutorily has been able to do. And when we're talking about things like Cambridge Analytica, we're working in a world where we only have unfair and deceptive trade practices, in which, for privacy enforcement in this country, it really requires that a company not live up to their privacy practices. At least our proposal does begin to give teeth and actual definite consumer rights to individuals and consumers. But once again, we're willing to work with others to go along the way to try to look at other options as well, too, that work for business and consumers.
I think the reason we have this problem is that entities like the Chamber of Commerce have opposed meaningful privacy legislation for 20 years, and serving up a stale version of these practices now is just woefully insufficient to respond to the complexity and the importance of the problem. But this is a hearing on the future, not the past, so I won't say any more on that.
So there's a very interesting issue that I want to bring up, which is the issue of data brokers. The FTC did a 6B study on data brokers, and what that study revealed was not surprising. I've studied data brokers for about 20, 25 years now, and something that's become very apparent to me, I was looking at business models of data brokers. So when I first started looking at data brokers, there was about a dozen or so major business models, but now there's about 50 or so business models. That's really complicated. And I think that if we're going to look at a problem, if you want a really hard problem in privacy, a really actually sexy problem in privacy, it's data brokers. If we can figure out how to address what do you do for consumers who do not have a relationship with a company, but the company has their personal data? If we can solve that problem, then we can solve a lot of problems. And that is why we're really looking at the voluntary consensus standards, because I do think that's a way to have surgical strikes. It's not a broad brush. It's a lot of different surgical strikes. That's one of the only ways you can get at some of these enormously challenging business models. We're going to need a multiplicity of approaches to solve the multiplicity of problems, some of which are very challenging.
Well, just to drill down on that, I realize you're suggesting a multiplicity of approaches, but just using the example of the data broker, I mean, what are the responsibilities of the first party to inform consumers and offer choice about sharing with a third party? And then what happens after that? What's the third party's responsibility to the consumer?
So I would really like to see appropriate notification to the consumer of what's happening. And it's got to be in a way that's clear to the consumer. But even better, I would really like to see consumers have a choice about whether it happens at all. And by that, I mean to determine best practices around what gets shared or if. For example, can we agree that there is some data that should not be shared in that fashion? For example, genetic data or perhaps by other biometric data. There should be some agreements that we can come to in certain contexts. I don't see why we can't find that. And another way of doing this is to say, are there standards that can be created with all the stakeholders present, having a discussion that is open and transparent and comports with due process, where we can come to some kind of agreements about acceptable data uses in that context and non-acceptable data uses that require consent. I actually think it's going to require some kind of process that has teeth. I'm not sure what will happen if we just get a written notice from the first party with no teeth. I'm just not sure that that will actually work in the long term. We've had that for about 25 years.
Well, I think it is very interesting, this concept of perhaps just taking certain uses out of the equation. But I mean, it sort of begs the question of what those uses are. I mean, to go back to the online behavioral advertising context, when we first issued a report in 2009, we suggested perhaps sensitive data shouldn't be collected and used for that purpose. It's very difficult to define what's sensitive. It's an incredibly subjective question. Just to pull in some of the other folks on the panel, I thought maybe Catherine or Rachel, if you'd care to weigh in on how you would make a determination of what sort of data shouldn't be collected and used, and how you define what is sensitive or what would be particularly upsetting to consumers.
Happy to. So maybe before I take that question, if I could just make a comment about the first party, third party data broker discussion that Pam was having. We agree that this is a very thorny issue. How do you convey to consumers what's happening kind of behind the scenes, what's happening that's invisible to them? And in some cases, it's not just third parties, but it's also first parties who are invisible to them, especially if you're interacting with a website. There's usually 10, 20, 30 entities that may be interacting with you, and how do you ensure that the consumer has knowledge of that and has some opportunity to consent? I think for us, we have grappled with this question of how do you define sensitive, what might be a prohibited practice, what might be a permitted practice, and we find that it is hard. This is line drawing, and it can differ depending on the sensitivity of the user. So Neil doesn't want to engage with me, and I feel kind of bad about that.
I would engage with
with my company.
You're great.
But how do we draw lines for Neil that may be different from the lines that we need to draw for Catherine or for me? And that's why we've kind of come back to this concept of saying opt-in for everything. It may be difficult to scale, but I think it's something that we need to think hard about because it has been difficult. And I'll just add one other piece to it is that, the idea of having comprehensive privacy legislation, I think, is helpful to hopefully minimize some consumer confusion in the sense that if there are strong privacy laws at the federal level, people have a sense of this is what is permissible and this is how I can control my engagement. And so I a little bit differ with Neil about, did notice and consent. I haven't given up on the notice and consent, and Charter hasn't given up on notice and consent. I'm not sure Cambridge Analytica was caused by that. There are the idea of having a strong law that consumers know what the rules of the road are, that the companies know what the rules of the road are. I think that could help prevent those types of things from happening: misuse, mishandling, misappropriation of data.
Catherine, do you have anything to add on that?
Yeah.
And Florencia.
So I think that having legislation that outright banned certain types of data from being collected or processed would be too drastic. There are just far too many industries and organizations that have reasons to collect and process all sorts of data that could be for very good and beneficial purposes. And I mean, even if we started with the GDPR model of having to at least begin with having a lawful purpose, to outright ban certain types of data collection would be even more drastic than having to start with having a lawful purpose. At SNAP, we focus on having substantive privacy protections for all users, things like having built-in retention periods for all data, shorter retention periods for data that we consider more sensitive, like location data or interests or behavioral data. And as I mentioned before, different types of privacy protections depending on where data is being collected. In terms of federal privacy legislation, SNAP believes that good federal privacy legislation would require companies to be transparent about their data practices, promote flexibility through privacy by design, as I mentioned before, and privacy risk assessments, incentivize good privacy practices through data minimization and de-identification or pseudonymization where possible. And I want to return to the transparency, making companies be transparent about their data practices as a kind of counterpoint to all of our discussion about notice, because I do think that there is a difference between companies giving notice of their data practices and data processing and being transparent about it. And I want to relate this to the transparency principle in the GDPR a little bit and suggest that we could borrow something from the transparency principle in the GDPR. And the GDPR, although the transparency principle and requirement is contained specifically in a couple of articles and it's actually, if you read the entire GDPR, which I'm sure most of you have, it really flows throughout the entire GDPR, the transparency principle. It underlies the entire law, and transparency is really essentially fundamental to all of data protection under the GDPR. And it's embedded in the very word transparency is all of those things that we want notice to be to individuals here in the United States, which is clear and understandable and communicated well. You don't have to say that when you say make your data practices transparent to individuals. It's right there in the word. And so at SNAP, for example, what we do to make our data practices transparent is have them communicated in multifaceted way. The privacy policy is the floor, not the ceiling, which is why when we give notice in-app in our just-in-time notices, it doesn't matter if we've said the same thing in our privacy policy or in our privacy center. What matters is whether we've actually communicated that in a transparent way to individuals. And the transparent way of communicating certain things is in the moment to the Snapchatter when they're going to use the product or feature, not did they read it in the privacy policy when they first registered for the app. We're quite realistic and know that most individuals don't read the privacy policy when they register. And so in order to fulfill the transparency requirement, we actually want to put the just-in-time notice up there and give the choice then. So that's where I think notice really can borrow from the transparency principle in the GDPR.
Thanks, Catherine. That was very insightful. There is a tremendous amount to unpack in what you just said, but unfortunately, we only have a few minutes left, and we want to be mindful of the other panels today. So what I want to conclude with is asking each panelist in 1 minute or less what you would like the audience to take away from today's discussion about notice and choice. And let me start with Jordan, and each of you have 1 minute. Thank you.
Sure, thank you. I think the most important takeaway today is that, as I said earlier, is certainty and control for consumers, and also having that cycle lead to trust with consumers and also with business. I think there is a definite place for notice and choice in the equation with regard to how data privacy is regulated. I also think there is a role for collaboration as well, and as actually the Chamber model bill, we actually have a safe harbor provision that enables some self-regulatory guidelines with FTC approval. I think there's a role for collaboration, and there's also a role for really meaningful privacy protections in federal legislation that would create certainty through removal of a patchwork emerging in the states.
Great, thanks. Pam?
Thank you. We didn't get a chance to talk about trust on this panel, but we are living in what Bo Rothstein describes as a social trap, which is where parties that would benefit from collaborating with each other don't trust each other, so they don't, and so they both get stuck. So they basically, we're all cutting off our noses to spite our face by not working together. And I do think that it's extraordinarily important to work together to find solutions in a way that encourages mutual trust. So I want to talk quickly about uses. We didn't really focus on data uses because of the structure of the panel, but I just want to bring up the Fair Credit Reporting Act and the Equal Credit Opportunity Act. It's important to understand that instead of restricting data collection, sometimes it's a lot more useful to look at the end uses as a way to try to work on things. But I want to end with following up on what Jordan said. Self-regulation is not going to be able to provide a safe harbor from the FTC. OMB Circular 119 provides that any any regulatory process that the FTC would, or any U.S. agency would join in, has to have a due process, has to be made with due process. So that would be a voluntary consensus standard. And I do support that as a way forward. One of the ways forward, I also support broad-based legislation and other tools and things that will assist. We need a lot of different tools.
Thanks, Pam. Florencia?
So what the takeaway point from the discussion, I think, is that notice and choice is complex, and it has many benefits in that it affords firms a lot of flexibility and consumers some seeming choice. But choice can be daunting, and consumers just are not informed. So just to add a little bit of data to the discussion and an analysis of the extent to which there's been compliance with the FTC guidelines by firms shows that it's been very weak, extremely modest at best, at most with 50% of the recommendations. That being said, I've noticed very intense differences across markets and in ways that are intuitive. So places where information protection matters a lot, there's been a lot of protection, and where it matters less, there's been less. That doesn't necessarily mean that the markets are working or there are any market failures, but what it does show is that there is a need and a desire by firms and across markets to have some flexibility in the approach. So this kind of strict top-down regulation prohibiting everything could create a lot of damage. Now, that being said, focusing on more notice is, in my view, barking up the wrong tree. And then there's been an interesting difference there's been some very strong spillover effects from GDPR. In May 2018, all of the U.S. privacy notices mostly changed. And the compliance with GDPR has shown some interesting changes, particularly when it has to do with with third-party contracts, data retention limitations, anything that's on the privacy by design approach that where a firm has to comply globally, all of that has changed tremendously.
Thank you. We're gonna keep people to a minute or less if possible. So, Neil?
4 points, 1 minute.
Okay.
First, notice and choice are not evil. They have virtues that Catherine and Rachel have pointed out in appropriate contexts, but they are insufficient to protect privacy and to protect consumers, which is what we are talking about. In practice, most notices are constructive and most choice is a fiction. Notice and choice, the way it has evolved in the United States, has been better at harvesting data than in protecting privacy and protecting consumers. Second, notice and choice don't scale for reasons I talked about earlier. Third, what we need are not the procedural protections of weak notice and weak choice, but substantive practices, and we need to develop those. And it's interesting that in both the Fourth Amendment context and in the consumer protection context with the FTC Section 5, standards have been more effective than rules. Finally, fourth, those substantive protections can include trust, something that Woody Hartzog and I have written a lot about. We think trust has 4 elements itself. Companies who are trustworthy, whether based on business incentive or coerced by law, are honest to their consumers. They are discreet. They don't share data unless it is necessary. They protect those consumers from breaches and bad choices that are avoidable. And fourth, they are loyal to their customers. And the duty of loyalty and the idea of information fiduciaries is something that is being discussed, but I'm out of time, so I'll stop.
Thanks. Catherine and then Rachel, and we have less than a minute. So.
2 seconds. At SNAP, we think that notice and choice can be effective in certain circumstances, especially when communicating directly to the consumer, but that it needs to be combined with other methods of protection where we use especially privacy by design. Rachel.
Thank you. So we support a framework based on 5 principles, and key principles included are the idea of consumer control and transparency. From our perspective, an opt-in control that's meaningful, that's renewed with frequency is important, and for transparency, we agree that it needs to be something that is communicated to the consumer, is clear, is readily available, and at the appropriate time.
Thank you all so much, and that concludes the panel on notice and choice. Thank you.
We're going to be taking a 15-minute
Okay, welcome back from the break, everyone. My name is Jared Ho, and I'm an attorney in the Division of Privacy and Identity Protection. To my left is my fellow co-moderator, Ruth Yodakin, an attorney in the Office of Planning and the Office of Policy and Planning. So we're delighted to be here today. We have a stellar panel of experts to discuss access, correction, and deletion rights. So starting from Ruth's left and going down the line, Jonathan Avila is the Vice President and Chief Privacy Officer of Walmart. Katie Race-Bryn is the FTC's former Chief Privacy Officer and current Chief Privacy Officer of 2U. Chris Calabrese is the Vice President of Policy at the Center for Democracy and Technology. Jennifer Barrett Glasgow is the Executive Vice President of Policy and Compliance at First Orion. Ali Lange is a Senior Policy Analyst at Google. And Augustin Gus Rossi is the Global Policy Director at Public Knowledge. So we're delighted to have them here today, and you can see their full bios online on our website. So today we'll kick off the panel with a moderated discussion on access, correction, and deletion. And Ruth, do you want to start off with the first question?
Sure, and I'm going to ask Chris to start with the answer to this one. We heard a lot of discussion about the goals for different privacy protection measures. And so we'd like to start off by asking, what do you see as the goals for giving consumers access, rights to correct, delete, and port data, especially in these days where there are complicated data ecosystems involving AI and big data?
Sure. Well, thank you first for having us represented on the panel. So I think the place to begin is by recognizing that this is only part of the solution. I know we've had a lot of discussions, and I won't bring in all the other parts of the solution, but I don't think anybody should lean on access, correction, and deletion as the sole answers here. But they are answers, and they do play some really important roles. I think the first is that they empower consumers. They really do allow consumers to have some certainty about where their information is going, what's happening with it, and provide some accountability for that. So I'll give you an example. So the app Grindr was in the news recently because they were forced to, the Chinese owners of the company are being forced to divest of it because of national security interests. Well, if I'm a U.S. consumer, I have no way when that transaction takes place, even before the divestiture happens, to say, well, maybe I'm not comfortable with my information being held by a Chinese company. So what should I do? How can I make sure that I have the legal right to delete that information and know that it's not going somewhere I don't want it to go? Well, that's why you need an access or correction and deletion right. I think that we also want to look at the time horizons at play here. These are going to be the rules for a very long time. I don't need to tell this audience how long many of the privacy laws in the United States have been in place. We're going to be setting rules up for years to come. So I think by setting a strong standard for these individual rights, what we're going to do is say to consumers that they can expect this. We're going to tell businesses that they can expect to build on this and build all kinds of positive, powerful tools to help consumers. So I think we're going to have a lot more on this, but I'll leave it there.
Go ahead, jump in.
So again, thanks so much for having me. It's so great to be back. So in addition to what Chris was saying about empowering consumers, I think having these rights in place also keeps organizations honest. So even though there may be a very small percentage of consumers who actually exercise these rights, companies and organizations need to have procedures in place to allow for access, to allow for correction, to allow for deletion. So it forces companies to know where their data is, to minimize data because they don't want to have to provide swaths of data if they don't need to, and and to provide mechanisms to answer those requests on consumers' behalf.
Go ahead, I think Jennifer, and then.
Yeah, I'd like to kind of amplify some of the things that Chris initially brought up. I would characterize providing more intelligence as a partial or improvement on transparency, not so much as was mentioned in the earlier panel, the sole solution for transparency, and I think we need to be careful of that. It does provide, in the right circumstances, and again, the earlier panel, I think, kind of highlighted some of those differences, some reasonable choices and controls. And it also, I think, should be tied to the reason for the request. And this is something that we don't talk about very often. But I think there are a number of reasons that a consumer might want to exercise their access rights. It may be pure curiosity about what's going on. It may be a decision that they're trying to make relative to, do I want to do business with this company? It may be a situation where I think the data they've got about me is wrong and it's having an impact, negative impact on me, and it's something I need to get fixed. Or it may be a situation where I feel like they are, and this may not be a consumer issue, but it may prompt an access request. The consumer or the agency feels like the company is in some violation of their own policy or accepted standards or other rules. So each of those, if you think about it, has some different dynamics to it. And I'll just warn you before we get started, you're going to hear two words from me fairly frequently. They were introduced on the earlier panel, so they're not new. One of them is context, and the other is reasonableness.
Gus, you wanted to add something?
Yeah, thank you. I think that Katie was right when she was mentioning that maybe some individuals, but not all of them, will exercise their access rights. But we shouldn't miss from the picture that having these rights would allow consumer watchdogs, such as Consumer Reports, Public Knowledge, ACLU, to understand better what is it that big organizations are doing with our data, and then that not only increases transparency, but also enables advocacy, enables consumer protection in ways that is harder to do in the absence of these rights. At the same time, I think that especially when we consider the relation of individual consumers vis-a-vis big organizations or platforms, there is clearly a huge asymmetry of information that tilts the balance of power towards one side and leaves individuals unprotected and consumers often unprotected. So having these rights is also a way to bring some symmetry information symmetry to the market, which in turn would contribute to make it work better for consumers and also for entrepreneurs.
So now that we've sort of discussed the goals of access, what are the types of information that consumers should have access to? Is it everything? Are there certain types of data where the costs might outweigh the benefits of providing that type of data? And I'll open it up and see if there's anyone that has an initial thought. John, why don't you?
Jared, again, thank you for inviting us to participate in this event. I think there are certain types of data, for example, very obscure data, the benefit of which providing it to consumers may be outweighed by costs. And obscure data are things, for example, on backup tapes, backup media. These are things which are not in active use by the entity and can be extremely costly to produce, restoring the backup media, extracting the information, then putting it back into a backup form. That may not be justifiable. Also, there's certain information I think that's extremely trivial. I mean, if we look at the original purposes of access and correction rights, they applied to situations in which the data could have a significant effect on the life of the data subject, FCRA, various other significant impacts. There may be trivial information which has little or no actual impact that perhaps also is at least not at the core of the purposes of access and correction rights.
And I want to return back to this concept of trivialness and sort of what the factors might include in sort of determining whether data is trivial or not. But first, I want to give Gus an opportunity to respond.
Yeah, so I think that one of the key challenges of this debate, of this series of debates right now, is that it's hard to get into the nuances of these rights or on these attributes in absence of a baseline privacy framework that is the reference that we're discussing about. So that's why I think that, in our view, the high-level principle should be that users should have access to all of the data. And then understanding that there might be circumstances in which that might be harmful for consumers, harmful for security, harmful for the normal processing of a contract, unnecessary, burdensome. And it's reasonable to understand that there might be some circumstances where that might be the case. But I think that we should start from the position of that assuming that users should have access to everything. And then organizations that have that data should justify and should explain, maybe in the process of debating legislation, maybe in the process of explaining to the FTC or whatever regulator in charge of enforcing legislation, why there are some pieces of information that should not be shared with consumers.
Yeah. Anyone? Why don't we go with Jennifer and then Ali?
Yeah, I think it was Pam brought this up in the earlier meeting. The connotation of use of the data, I think, is extremely important in thinking about this, partially because the systems that we would be drawing the data out of are driven a lot by use. And by that, I mean things like, is it required or part of placing an order or fulfilling the transaction or handling customer service associated with the business? That kind of is one big category of use that you can say, well, what kind of access do you need to that? Another is internal operational use. Some of it may not be personally identifiable, but depending on the industry, it may be. That's another type of use. We also mentioned earlier this morning fraud and risk data that the company is engaged in as being something that typically we don't allow access to. I mean, a bank's not going to allow access to their fraud detection systems to make sure that the transactions, to the algorithms that are looking at the transactions. So we might make different choices there. Sales and marketing, maybe there should be, because we want to give the consumer more rights or choices to opt out. Research, data that you've got in your possession that you're working on for research purposes, is that subject to access and correction or deletion? And then finally, and I call it data monetization. This is where you're using data about individuals to actually either sharing it and selling it or allowing third parties to use it within your own enterprise. You're monetizing or making products out of data, in other words, and that's another category that might have some reasonable expectations in it.
Ali?
I think this is an awesome discussion. I really agree with Gus's instinct that for the most part, data should be available unless it conflicts with another sort of purpose. I think Jennifer laid out some really good examples. You might have a legal obligation to keep some forms of data. You might have, instead not let it be deleted, you may have some reasonable limits on some other types of access. But it's interesting also to think through, like we've so far in this discussion talked about these three types of controls as if they need to apply kind of all or none. And actually, if you had portability, there'd be sort of four general things we're talking about. And for each type of data, there may be different parts of access control, deletion, and portability that make sense for people, that makes sense given the context, that makes sense given the obligations the controller has in other contexts. But I would encourage us not to be too narrow in thinking about the reason for the request. I think that there's some utility if you start from the presumption that you should be offering availability as broadly as is sort of reasonable, given those other constraints. We don't need to know too much about the non-nefarious motivations people might have. Obviously, you want to prevent fraud and other things like that. But the sort of beauty of these tools is that they can be applied broadly, and you don't necessarily need to have some reason as the consumer to exercise them, right? It may just be curiosity, which is a totally valid use case. The interesting thing that will happen as people become more familiar and there's some muscle memory that's developed around taking advantage of these types of offers, is we may see some really interesting kind of examples and use cases and discussions and debate that come out of these tools. And I think it's just, worth noting that at Google, we do see quite broad use of the tools that we've made available, just as sort of a baseline example. And we can chat more about some other specifics later. The Google account page, which is where you have your settings and access to all of your other kind of the account information that's stored with your account and other tools like that, gets 2.5 billion visitors a year or at least last year it did, and it's going up every year. So there's certainly interest in this. There's certainly people who are engaging with things that are available. And I just think that if we think through the three things, you can tease out the four of them a bit more and not necessarily put people in a position where it has to be an all or none scenario.
And just to piggyback on that, because I agree, I think the default should be to have access to these rights. Sometimes I think we think of these as individual rights, and they obviously are, but that doesn't mean that we're expecting that the consumer is going to do everything to unpack the value of these things. So I think a good example of this is in the financial services industry. For years and years, we've had financial apps, think Mint, that look at consumers' data held by other parties and help those consumers use that data. And for years, they did that using basically, essentially, you give your password and username to Mint, and Mint would then go to your banks. Tremendously insecure. Nobody loves it. They're now moving to more of an API-type process. And that has the benefit of security, but it also has the benefit of building an entire ecosystem. There's new apps like Plaid and Yodlee that are using this information to help people budget, to help people make payments. This is unpacking value from data. And I think that when we think about these rights, we need to think about them in the context of how we can take this tremendous digital economy that we are at the very beginning of and put it to work for consumers. And I think that if we think about it in that terms, think about it in the terms of what kind of system do we want to build, what kind of world do we want to build for data over the next couple of decades, it becomes really obvious why we'd want to invest in the front end on the technical capacity and broad use of these kind of rights for consumers.
Okay, well, if I can move it along to that idea of what companies need to invest to set up an ACD system. We had mentioned by Jonathan of what's needed to pull up old tapes from the basement. And Jennifer, you also mentioned a bit about what goes on in terms of the normal processing, and this may be something that can be incorporated to existing systems. So maybe, Jennifer, if you can start us off and talk about what companies need to make something like this happen, but also, if you can, just we'd like to hear some comment on discussion that took place yesterday about whether some companies are going to be better able to do this than other companies because of their size.
Yeah, I'll put the size question to bed quickly and first, and then we can get on to the more complex one. It really is more driven by your systems than your size. If it's a legacy system and we never contemplated the need for access and or correction or deletion, then it can be very difficult. And I'll give an example here in just a minute. If it's a new system that you're designing today, I hope we're beginning to take some of these factors into account as we roll out new technologies. And I think we've seen that in certain industry sectors where access tends to be, we feel like it's more needed. But for another dynamic here, to kind of put it into context, as I said, you're going to get tired of hearing that word, is whether there's a first-party relationship with the consumer or a third-party relationship. That came up a little bit on the previous panel. It's much more complicated for a third party to provide access than the first party, because the first party has a username and a password or some other means to interact with the company, an account or a credit card or whatever, whereas a third party may not. And in my previous life, with one of those big, bad, evil data brokers, I say that literally because I spent 25 years being the privacy officer for one, we put forth a voluntary access and correction and deletion system for the marketing data. But it meant creating a whole separate repository for that data, because the data at the time was not accessed on an individual basis. It was accessed in bulk. People don't want to market to one person. They want to market to a group of people that have certain characteristics. That's replicating the data and then keeping that replication up to date with all the changes that are going on in the various systems. So that turned into quite a expensive and time-consuming operation. So again, I would maybe summarize by saying how new or how old the system is may make it practical or maybe even impossible. And then for certain types of relationships where it's not a first party, it may be harder. And I'll mention one other thing, which I think we may come back and talk about, and that is any access request needs to have an authentication activity associated with it. And that could be fairly straightforward or simple if you have an account. It could be fairly complicated. It also depends on the nature of the data. If the data is highly sensitive, then the authentication needs to be very robust and rigorous. If the data is not as sensitive, giving someone access to it that isn't the person they claim to be maybe has fewer consequences.
Katie, and then Jonathan.
Yeah, so I just had two follow-up points building on what Jennifer was saying. So, one of the criticisms about GDPR was that only the big guys were going to be able to comply, right? And that it would end up becoming a competitive advantage because small companies may either remove themselves from certain markets or not engage in certain business practices because they wouldn't be able to have a lot of the controls and requirements that are needed under the law. So I think that is true of any kind of regulatory scheme, is that if it's expensive and complicated to comply, then there may be kind of advantages to incumbents or to companies that have more resources. And then building on Jennifer's point about legacy systems, so my company, we're an education technology company that works with colleges and universities to provide online graduate programs and short courses. So I'm constantly talking to university partners, and the legacy system point is a really huge issue for a lot of universities, that some of whom have been around for hundreds of years. Now, there are requirements under FERPA that are similar to GDPR and other the California law, in that there are access requests that must be complied with for students to get access to their student records. There are rights to inspect education records. And so universities have been dealing with these sort of rights for many, many years. But the idea of an education record is really cabined in a way that broad definitions of personal data are not. So they're definitely struggling with how to address these, a lot of these access requests when you have really antiquated systems that may not be talking to each other.
Yeah, and I'd like to reinforce both what Katie and Jennifer said, and I think the distinction is not between large and small, but between legacy and new. And sometimes, and even among large companies, that is very much the case. Sometimes we take the large, relatively new integrated tech companies and treat them as the model for what is easily accomplishable. So we see they've already built a portal through which their customer data is accessible. Why can't every company do that, or at least every large company? And it very much is the difference between relatively new companies that have a limited set of product offerings directly to consumers with integrated systems, as opposed to older companies that may have a very diverse set of product offerings with legacy systems. For example, if you're a big box retailer, you may be collecting data at your auto center where you have records about people's automobiles. You may be collecting data at your financial services center where you do check cashing and money forwarding. You may be collecting data about consumers where you're selling them cell phones and you're assisting them in signing up for carrier cell phone plans. That data may not be integrated at all. I think sometimes there's a presumption that large companies know everything about all their consumers and they have total knowledge. In fact, that often isn't the case. So the difficulty of accomplishing an access request when you have disparate systems, and of course those systems don't have a hard key match. So they're not keyed on Social Security number. So my name can appear as John Avila in one system, Jonathan Avila in another system, John Avila in a third system, and then that's compounded if I've moved from one address to another. And this is an issue of data quality, but executing an access request, for example, across all of those systems, very difficult.
So,
Us and then Chris.
Oh, sorry. Yeah, I think that definitely it's going to be very hard for some companies to comply with all these rights, and maybe because of their systems. And I think that that's why it's important that in legislation we identify both what's the threshold of obligations for depending maybe the size of the company. I don't think that the system should be the threshold. I think that if a company collects a lot of personal information and it cannot keep it it cannot keep it in a way in order to guarantee consumers' rights, maybe that company should reconsider whether or not it can or it should keep collecting so much personal information, and that's going to be transition cost to pay. And I think that a way to diminish the costs of this exercise is perhaps for the FTC to identify which are the dominant players in each sector of the economy that should be subject to a different set of obligations or with more stringency than other players. So, for example, there have been, like I think in CCPA, there's a limitation of how often a consumer can exercise her right to data portability, right, to twice a year. I think that might make perfect sense for a small supermarket, that might make perfect sense for a nonprofit. It might not make sense to allow Google or Facebook to stop a consumer from asking for that data when the marginal cost of providing that service, like 10 times a year, is zero once you have the system. I think all those nuances are important as well. And also, especially considering that how often consumers get to exercise these rights is going to influence and limit both the capacity to exercise the right to data portability, and as Chris was saying before, more importantly, the right to interoperability, to interact with the data from different services. If we start limiting that at large for every player, we might end up like actually entrenching the power of dominant players in the market, and we might end up like making true those fears that if we pass a stringent and comprehensive privacy legislation, we might end up in an uncompetitive market that we don't want.
So I'm gonna push back a little bit on. I think it should have nothing to do with size. I don't think that. I mean, it's been said many times. Cambridge Analytica was a very small company. They had a lot of data. I do believe that this is not as big a problem for most small entities. I think that just like you have a third party that handles payroll, you'll have a third party that handles some of these compliance obligations. I just don't think it's going to be that big a deal. The medium-sized company may end up being the harder one, actually, because they're big enough to maybe have a lot of data, but maybe not quite be able to have that kind of bespoke option. But I do think that we should keep in mind, first of all, there is going to be a transition period for whatever law we have. I mean, GDPR's was 2 years. There's going to be some time. And I also think that reasonableness cures a lot of problems in this context. It doesn't solve every problem, but I think that we should be mindful when we're thinking about edge cases that there are going to be reasonableness requirements. We are going to have situations where, I suspect strongly, just from looking at the variety of proposals out there, that being unable to comply with the strict provisions of an access requirement at the first month after the law is passed is not going to be a corporate death penalty. It's just not, right? It may get you a visit from your state attorney general. You may have to figure out some compliance. I just don't, but it's not going to be the end of the world. And when you weigh that against the tremendous potential benefit of allowing consumers to have this kind of access, to use their own data, I just think it's a no-brainer. And I think we should be careful about cabining the individual rights around short-term use cases that I think, frankly, can be overcome with some time and some energy.
If I might just follow up for a moment, I think Chris is absolutely right that this isn't an issue of should we do this, shouldn't we do this. It's a matter of how regulation is implemented. There has to be an adequate period for implementation to deal with legacy systems. There also has to be adequate regulatory guidance. A situation in which, for example, regulations can be issued about how requests will be verified up to 2 or 3 months before the effective date of the obligation is not an ideal regulatory system. As Chris noted, it was 2 years, the implementation period for GDPR. The text was established at that point. There was some regulatory guidance after that, but the text was reasonably clear and also had been debated for quite a while before it was enacted. So those transition periods are really vital in these situations.
Okay, so we've mentioned GDPR and we've also mentioned CCPA at this point. So, there are access and correction and deletion and portability provisions that currently exist in, various frameworks and codes of conduct. So for those of you, with experience with these various, laws, GDPR, CCPA, and, others, can you point to specific examples where access, correction, and deletion are working in those models, and perhaps where some of the challenges lie in those models? Katie?
Well, I'm going to talk about the Privacy Act since as CPO. At the FTC, I spent a lot of time thinking about the Privacy Act. And so, the Privacy Act was passed kind of in the wake of Watergate to provide transparency, which is a word that we've heard a lot today, to citizens about the personal information that government agencies hold on them, right? And there are certain aspects of the Privacy Act that you see kind of reflected in, both legacy and kind of a lot of these laws that we're talking about and potential regulations that are coming down the pike. So from a transparency perspective, agencies are required to publish system of records notices, which kind of describe what information is held in which system about individuals, and they have to be updated when the system changes, and there are kind of a lot of disclosure requirements. They're published in the Federal Register. And then citizens have the ability to request, under the Privacy Act, to request information about what records agencies hold on them, right? So this is sounding familiar with a lot of the GDPR requirements, CCPA requirements. And individuals do not have the right to access any records about anyone other than themselves, right? So it's limited to just information about them. And then they also have the right to correct data that is held in these systems that may be inaccurate. So, I think a lot of the government agencies have been dealing with a lot of these requests and have been dealing with being able to provide access to their systems for, since the 70s. So this is, in some ways there's kind of nothing new under the sun. But the way that the Privacy Act, I think, as we definitely struggled with this, the FTC, and when we're working with our counterparts across the federal government about, the Privacy Act really looked at kind of an individual file folder that had papers in it about you. Mm-hmm. And that's not really the way that the world works anymore. We have combined data, we have very complicated data systems, and when a request comes in, how do you deal with that shared data, which I know we're going to talk about a little bit more later, and what's the breadth of the personal data that the individual has access to. But I think that these ideals about transparency, making sure that organizations are clear about all the information that they're gathering, and then having these access rights is something that has been true in the federal government context, at least for many years.
Ali? I actually have a really interesting story that I think helps answer the question a little bit from one perspective, and it's about data portability. So when Google was creating the data portability tool that we've sort of conceived of over a decade ago and has been iteratively improved on, or we hope improved on over time, the original kind of idea of it was actually born from a quote from former CEO Eric Schmidt, who said he doesn't want people to be at Google because they feel stuck. And so a team sort of took that idea, ran with it, said it should be easy for people to take data and leave the company if they feel like they want to do that. So the system was built, and as it turned out, for the most part, what we've seen over the last decade of making this tool available is people don't, for the most part, use it to leave Google. They use it to download a copy. They use it for curiosity. They're curious what's in their tool or what's in their account. They're curious where they might be able to take that data. They need to move things from Google to Microsoft OneDrive. There's a lot of use cases, and sort of the I'm fed up and I'm taking my data and then I'm going to go delete it. turns out to be at least not the dominant use case. And so there's a couple of really interesting insights from that example. One is, as I mentioned earlier, we shouldn't let our imagination or our sort of vision of what these tools are useful for be the end of the day, right? There has to be some room and some like consideration and continued observation of how people are actually using the tool. Once we understood that it wasn't necessarily the primary use case to sort of like leave, but instead to go somewhere else, try something new, to have a copy, it really informed the way that we continue to iterate on and provide that tool to make it easier for people to use it for the things that they were actually using it for. And among those things that I think is the most interesting is really the benefit of that type of tool is it enables people to try something new, right? It makes it easier for you to say, I'm not ready to leave this one particular, like there's a bunch of, for example, we could take a non-Google example. There's companies that do, you make a map of your exercise if you go outside and you make a map. I'm not ready to leave the company I'm used to, but I want to try this new one on the market. So maybe I'll take some of my data, put it in there, see how it looks, see if I like it better. If not, I can kind of, keep it and switch back and forth. Or maybe I like to use 2 of them, or maybe I like to use none of them. And you can have the rights that apply to that. And for us sitting here in the US, this may seem like, oh, that's really a nice thing to have. But in economies where there's still more volatility around startups, where there's still more sort of volatility around stability and there's a lot more emerging innovation, it's a really big deal to be able to feel like you don't have to make a choice between trying something new or sticking with what you have, that you can sort of experiment, find the thing that works for you, and as products and tools change over time, to continue to make that decision as it makes sense. So I think it's a really interesting use case for both how the creation of these tools needs to be done in a way and observed and modeled in a way that continues to allow the expressed interest in them to become, to develop on its own and to become a sort of reason for them to exist. And also that there's, utility to the economy of enabling people to try something new and to lowering the stakes for that.
Jennifer, and then Gus, and then Jonathan.
I really want to pick up on the concept of what is the consumer want portability for. I tend to not think of it in the same context as access correction and deletion, but more of a business feature. Am I going to take my American Airlines traffic history and move it over to Delta? Am I going to take my Marriott hotel history and move it to, whatever one of the other brands are, and I lose track of who owns what now?
Marriott owns them all.
Right. So I think we have to look at it in the text, and what's the ownership of that from the company standpoint? Are we providing competitive intelligence by having a consumer do it, and of course then the cost to do that if it's not something that the consumer actually wants and can benefit from or has some vested interest in. So in general, you might try to think of that as if I have contributed data to this, or if there is a long track record of data that I may not have participated in contributing or providing. Maybe there's some value if it's just my transaction history at a retail or not. But then you get into unique situations like in healthcare where I do want to take all my medical history records and move them over. But that's very industry specific and very context specific. So I think talking about data portability in a real broad general right can lead us down some very troublesome paths.
Gus.
Yeah, so I think that it's very hard for consumers to understand the value of their data when the data is locked in somewhere, right? So when you can see it, as we talked before, if you see that you are classified as someone with very low incomes and low income, you might start understanding why you're not receiving ads for certain jobs, or if you see that you're being targeted for publicity regarding your location, then you may understand why you're being discriminated in certain ways. So I think that on the one hand, it empowers consumers in general to exercise their civil rights, but at the same time, given the rights for access, correction, and deletion, and then as I said before, I think that the GDPR has a great balance for the situation, which is saying that you have those rights as long as those rights don't infringe on other people's rights. So I think that that's a very decent guiding principle. It's important, but that's why I think that data portability is key, because it's like it's actually a meaningful way of exercising these three rights. And I agree with Jennifer that maybe most consumers don't think today that it has any value to get or defy information from American Airlines or United. I use United because I have here. And, it might have, for some of them, it might have value for a startup that if you have access to that data can offer you a better way to book your tickets with United. It might have some value for you to actually go on, if you have built miles with an airline, to go back to a different airline and say, like, not only have like this status, these are my regular flights, what can you offer me so I switch? But I think that the most interesting part of European law that we should try to see as an example is the Second Payments Directive, which basically in the UK has been implemented as the Open Banking Initiative. Basically, the Competition Authority of the UK mandated that the 9 largest banks in the UK have to open their data and create a consortium to develop open API systems to allow fintech third parties to both interact in real time with that data and including for the exercise of payments that consumers have. And I think that's the kind of like access, correction, and deletion rights that meaningfully transform the marketplace and empower consumers, put consumers back in control.
I know we're running short on time, so we're going to move on, but we'll give everyone opportunities to get their thoughts in. Ruth, do you want to?
Yeah, so just to dive into some of the items that were raised, we're interested in some of the particular challenges, the actual challenges to making ACD and portability, if you count that separately, happen. And in particular, some of you have raised the issue about authentication. So that and other items. Anyone want to start us off? Chris, you want to start us off?
Sure. So I'll start off by cheating and making the point that I was going to make.
I thought you might.
But it is a challenge. All right. So we have the blue button regulations that are coming forward right now, which is giving people the right to port their information out of their medical record and in somewhere else. Well, we're giving consumers, we're actually mandating that consumers be able to port their right from a highly secure, privacy protective regime, which is to say HIPAA, to a wild marketplace that has almost no controls over and protections for that personal information, certainly as when compared to HIPAA. That seems like a pretty big challenge. I mean, I think that's why these rights have to be viewed as part of a comprehensive framework, because if they aren't, you have the real possibility that you're going to take information you think is highly protected and bring it somewhere else. Having said all that, I will now actually answer the question and say, I do think that we do have authentication issues. I think that there are a lot of use cases where authentication issues aren't that big a deal, certainly in the Google context where you have a lot of authentication already in place. I think that in the case of third parties, we do have to authenticate data, but it's also incumbent upon the third party as the person who's holding the data and the person who's deriving value from it to make those authentication provisions work.
Go ahead, Jonathan, and then Jennifer, if that's all right.
If I may, I think one of the most difficult examples of authentication is where you have a third party who's representing the data subject, and children's data is the most obvious one of those. There also are some provisions, for example, in the CCPA that would enable third parties to represent data subjects. But in the area of children's data, you have not only the authentication of the child, but the relationship between the requester and the data subject, between the parent and the child. So if we look to COPPA, I think COPPA offers some instructive guidance about how to handle that, because COPPA has its own access provisions that permit the data controller to exercise reasonable means of authentication and also provide a safe harbor where the authentication ends up being incorrect, where there's somebody who is incorrectly authenticated as the parent of a child. And that's a very sensitive issue, a very sensitive area of data. I mean, I think to the degree that we extend rights to third parties to make requests on behalf of data subjects, we have to really consider the risks there, because they are exponentially greater than they are in direct data subject to requester situations.
Let me just give some practical examples, because I think sometimes they speak louder than us talking about it theoretically. Again, in my experience, going back a number of years, in fact, this goes back actually to the 90s, where there was some self-regulation that ultimately got consumed when GLBA and other laws went into effect relative to data that was used for risk decisions. Risk systems have a lot of very sensitive data in them. They have Social Security numbers, they have driver's license, they have data, they have the keys to identity theft. You can kind of summarize it that way. Giving someone access to that and not being absolutely as confident as you possibly can be that you're dealing with the right person creates a couple of risks. Well, many, but I'll highlight two. The first is, you're potentially putting the actual real party at risk because this data is going to someone that's probably trying to get it for nefarious reasons. The other is that they are the risk that the requester wants to change the information for this or delete the information for the sole purpose of getting around its primary use, which is to identify you, comes to play. So, as I mentioned earlier, I think it's a scalable kind of thing, but companies have the right to say, I don't have confidence that I'm dealing with the right person. The example that always comes to my mind is the risk data that we used to have, where we allowed partial access because if it was wrong, that was bad. So we needed this, we had an accuracy component that had to come into play here. But we didn't allow deletion. And if it was to be corrected, we had to independently verify the correction with another party, because the correction was exactly what the bad guys wanted to try to circumvent the system. Now, that's an extreme case, and I don't know that it applies in every situation, but I think it's an example of where, when you take into account all the factors and put the request, whether it's to access, correct, or delete, into context, you can come up with a reasonable decision, to pick up on your word, that works for everybody. There's a balance between, I feel like we need to introduce the concept of fairness for both the individual and the company. And I think a lot of the discussion up to now has been focused on the individual because they haven't had some of the rights that I think that we're trying to give them in our movement towards more legislation here in the United States. But I don't want to forget the fairness to the company while we're doing that.
But if the company is deriving all the value and the individual isn't deriving any value, that balance seems off to me, to say we need to have the company have fairness, but wait a minute, it's the company that's getting all the value. It seems like they need to be spending more time with the consumer because the consumer's not really getting anything from
Well, the individual is getting fraud prevention.
Well, maybe. Or the individual's getting denied credit because they're wrongly being identified as fraudulent.
I don't think you can say that there's necessarily no benefit.
Well, I'm not saying there's no benefit. I'm saying the benefit is pretty sharply skewed. Take people search apps. People search apps don't do a lot for people. They do a lot for people who want to search for people.
Here's where I think you can take a bunch of different industries and come to a different answer on each question when you drill down in it.
Okay. Can I just have one quick addition with a concrete example that I think is helpful, that I do think companies have to balance whether there are other reasons why data needs to be retained, so particularly in when there's a deletion request. And I think some companies are so nervous about GDPR compliance that there is perhaps an over-deletion happening, and I do think that there is a real threat of fraud as part of that over-deletion. So one example from 2U's context is that if an individual applies to one of the 2U-powered programs that we run, and then asks to be deleted, we and the university registrar needs to maintain some minimal record, right, that person applied, let's say, and was denied. If everything is erased on that individual, then you can see how there's an opportunity for fraud there.
Okay. Okay, so moving on to the next question. To drill down and get into even some more trickier and thornier topics, I wanted to ask about about shared data and inference data. So, sometimes the information about companies, the information that companies have about consumers include not just information that consumers contribute themselves, but what might be contributed by other users as well. Photos, that are tagged, for example. On top of that, companies might use the data that consumers have provided to create new types of data inferred, and we heard a little bit about that in the last panel. When we're talking about this balancing, Katie, how should firms look at that? What are consumers' rights with respect to either type of information, and whose rights should sort of ultimately win out?
Well, the way that we've looked at it is we've tried to distinguish data that just pertains to one individual. So think about like the papers in a file, not actual papers in a file, but something that can just be tied to one individual. And then shared data. And so 2U holds tons of shared data. So as part of all of our programs, we have live classroom courses, right? So we have 20 people logging into our learning management system who are interacting with a professor, who are chatting, who there's video, there are images, there's voice recording. And so if somebody asks for that video to be deleted, well, what about the other 19 people who have rights to go back and look at that lecture when they're studying for their final exam? So the way that we deal with that is we look to see how or if personal information of any particular individual can be obfuscated, and hopefully in many cases it can be, but there are cases when it cannot be. And I think in those cases, organizations need to balance the rights of other individuals who may be impacted by the deletion of that sort of data, and again, make a reasonableness decision. Is that there's a balance here. How do you balance the rights of two individuals who may have different interests?
I agree. I think that it's important that the organizations can balance the requests regarding the rights of other consumers and also legitimate business interests. So, for example, the execution of a contract, preventing fraud, or security reasons. At the same time, I do think that it's important to keep in mind that these principles make sense in the context of a comprehensive privacy bill that also empowers some regulator to both protect consumers when they recourse decisions of organizations, because otherwise it doesn't work. It's very easy in the absence of a law and a regulator that defends consumers for organizations to simply say like no to all requests, because it's going to be cheaper, it's going to be easier, it's going to be less complicated, right? So like, yes, that principle of like allowing organizations to balance the requests makes sense in the context of comprehensive privacy bill that details, at the very least, what are things that consumers have rights for, and empowers an agency to police bad practices by organizations. And I think that something that we should keep in mind is that what's inside this comprehensive privacy bill, this baseline of privacy protection, might determine how much information companies, organizations are going to be willing to collect or not. If there is a mandate for data minimization and privacy by design and by default, then things change dramatically. A problem that we have right now is that the default for many organizations, especially in the tech sector, is to collect as much information as possible and figure out what to do with that data later. And that creates problems for consumers. And so that's maybe something that should be discussed as well, because that will change as well the incentives for organizations to collect information and to determine what you have access to and how easy it is to provide you those access.
I would just note that I think Katie raises a very good point, which I would phrase as the integrity of the historical record. And the emergence of the rights of deletion, for example, in the European Union, the European Union has a very different concept of rights of free expression. The rights that we accept as absolutely normative under the First Amendment don't exist to a large degree under European Union law, and there are several notorious, I would call them, cases of the European Court of Justice severely limiting rights of free expression in favor of rights of data privacy. So the integrity of the historical record, I think, is important when you come to rights of deletion. There also is a commercial speech doctrine under the First Amendment in the United States, and that has to be taken into account when considering how these rights would be imported from Europe to the United States.
Ali, and then we have to move on.
And I want to make a couple of points. The first, without undermining the achievement that the GDPR is, I don't want to give it too much credit for inventing a lot of these concepts. A lot of this has been around since before the GDPR. Companies such as Google have been confronting some of these challenges in a practical sense for a long time before the GDPR. I think they've provided some good examples that were considered under the sort of guidance and advice given as a result of that document. And one of the interesting sort of test cases I would provide in this context is, one thing the product teams talk about a lot is the user's mental model. So when you're talking about shared data, I think Katie's example was incredibly rich in detail and an incredibly sophisticated question, but you can even look at something like email. Like, is email a shared data type? And the mental model for email, because email is sort of one of the original data types for the internet, right, is I have a copy and then I send a copy to someone else, and now we both have a copy. So mentally we think there's two copies. Like, if I send an email to Chris saying, hey, great haircut, and then he deletes it, like, I disagree with this, I don't think that I have a good haircut, then I still have that record that I sent that. And so if I were to access my email or download or do anything to my email, it's sort of a standalone idea. You can look at something like what happens now with the cloud, where you would share a photo. Like, if Chris shared a photo and said, hey, look at my great haircut, and he shared it with my account, and so I could access it, and then he deleted it, I would no longer have access, right? And I might choose to remove it from my account. I might say, I don't want to look at this picture, but it's not the same as being able to delete it. So there's an interesting mental model progression that's happened over time, and it's not that we go back and revisit old data types and force them into new mental models as we evolve, but you may have sort of coexisting and competing in different kind of models. And I think Jennifer's use of the word context is really important here as well, as we're thinking about, what role do legal frameworks or what role do sort of norm-setting frameworks play. And it's important to keep in mind that at the end of the day, it's really how people are using something, how people think of it, what's intuitive for them. That also needs to be prioritized and also needs to be considered in terms of making a system that responds to those needs.
Okay, we're going to switch gears slightly using a hypothetical that you all are familiar with, and it's in front of you somewhere, to see how you'd actually apply this and what you think is most important here. So basically, Company X is a video game company. It allows gamers to join group games, make in-app purchases. It collects some information directly from consumers: email, username, country, profile picture. Users can build profile pages, allow other users to comment, tag photos, private message. And as consumers interact with the games and other players, the company collects metrics about purchase, transactions, history, games played, screen time ranking, maybe even IoT device use, and scores. And the company generates inferences about the consumers, such as skill level, low, high in-app purchaser, risk taker, and the likelihood that the consumer cheats.
So that was a lot to take in and absorb, but I think we just wanted to at first focus in on access and sort of tease that out a little bit. In fact, try to figure out what the different levels of access that the company should provide to consumers for the A, data that is directly collected about the consumer, B, the data that is shared, and then 3, the inference data that's generated by the company. So we're drilling down from like the abstract question that we had to a more specific one. So anyone want to kick us off?
Well,
go ahead.
Go. Sorry, I was just going to kick us off with something. Some of my staff actually play video games. I'm not that cool, but so this is not. It turns out not actually that hypothetical, right? And somebody immediately pointed out to me that. There was an article recently where a gamer figured out that he had spent about $10,000 over 2 years playing FIFA Ultimate, which is a soccer game. And that he found that out using his access right under the GDPR. And that was almost all under microtransactions, very small dollar purchases that came in the game format. So you could immediately say, boy, that's a useful piece of information, right? I might want to spend that money on something else. But you know, it's hard to necessarily know that as kind of like in the moment, but using that access rate, you're able to really unpack valuable information for you. And I think that kind of example says, oh, okay, like I might even want to build a little app on top of it that says, you've reached your $500 limit for the month, you know, maybe you should not have any more microtransactions for a while.
Can I respond to Chris before I go into the question?
Of course.
I think you're right. It's great to have that kind of knowledge. I'm not sure a right of access is the right way to get it. So I would separate business functions from the kinds of privacy rights that we're talking about here. That would be my only comment.
I'm sorry, but you think the consumer should get it, but you wouldn't call it an access right?
I wouldn't. Well, I think, you know, maybe the app ought to have a feature that shows you, you know, your billing. I mean, think about any other kind of billing statement that might come from a company. A right of access is probably the least frequently used reason to get that kind of information. But let me go back to the question at hand. I think it's great that we're beginning to look at the different types of information provided by the consumer, information that is generated by the interaction through the company, information that's observed, and then information that's analytically derived, like maybe the cheat score. Each one of those has some different dynamics that I think need to be taken into account. And this is where things like privacy by design and other things can really come into play when the app is launched and people are beginning to use it. To talk about access to the data that's collected by the consumer, you know, yeah, that seems reasonable. I provided it. I may not be particularly interested in it because I provided it and I know what they've got. What I tend to be more interested in is the data collected through the interaction. But interactions has an interesting dynamic in that data is constantly changing. Every time I get on and play the game, my costs go up or the charges to me go up. So the question becomes, what is meaningful to the consumer in terms of access to a piece of data that by the time I get it and have a chance to think about it, it's changed potentially or it's moved on to something else. And I think it creates an interesting dynamic. I think someone in the earlier panel mentioned we haven't figured out the rules, I think it was Pam, about artificial intelligence. And while this may not be an artificial intelligence application, it has some of the same dynamics that we will have to work through, and I don't know that any of us on this panel have that answer today. When you get into photos and messages, now you get into some of the shared data issues that we're talking about. And then the risk taker, I guess, as I was thinking through my answers on some of this, is any of this data shared with a third party or not? That was not specified in the scenario, but I think it would alter my answer if it was or wasn't to potentially a small degree.
So, unlike Chris, I am cool and I play video games. And I play FIFA. And I think that I don't see any scenario in which I don't see why consumers shouldn't have access to all this information, right? They observe, they infer. I think that it's valuable for consumers. Maybe there are some situations in which it's not. I mean, maybe it's bad for very negative for the security of the service to allow a user that is a cheater to know that the company knows that user is a cheater. Maybe that information should be withheld, right? But that should be on a case-by-case basis, and then, again, it would be useful to have legislation and oversight. I think it gets more delicate when we're talking about correction, right? So maybe you should not be able to change, in this case, your skill level, right, on correction. That affects the gaming experience. But for example, in the case of credit rating services, if they have the wrong number for your income and that's affecting your capability to get a mortgage, then maybe you should have the right to correct that. Maybe the right shouldn't be just a click, but maybe you should provide some documentation, but it should be there. The same with right with deletion. And I think that we should consider different cases, right? It's like if you are you decide that you don't want to play FIFA anymore, you want to go and play Pro Evolution Soccer, which is the other big game, you should have the right to delete the information that the EA Sports, the company that makes FIFA, has from you. Or at least most of the information that is not necessary for the provision of the service. Which at the same time, it's very reasonable to argue that the information that will be necessary for the provision of a service and improvement of the service could be anonymized, so it shouldn't be identifiable data anyway. So it shouldn't be within the realm of privacy protection. And that should be a case as well. And to Jennifer's point, sorry.
No, sorry. Can I just interrupt real quickly? I just want to ask one question, then Jonathan, you can respond. But you mentioned the deletion issue. What about like in the scenario, the likelihood that the consumer will try to cheat? Should they be able to delete that information?
I think that, again, like that should be a base for if the organization perceives that as a consumer that is trying to cheat, and it's harming the experience for the rest of consumers, maybe that's a base for not deleting that piece of information. It shouldn't be an all or nothing situation. But so understanding that there are like significant nuances, and organizations should have the right to balance the rights of consumers with other priorities. But that's a case-by-case basis, and that should be forced by an agency.
I will just offer, sorry, we talked to some game developers. They said they view this as a cost of doing business. It's anecdotal, but they view letting people delete it and then having to re-identify it as just a cost of doing business, just for whatever it's worth.
I'd just maybe note a broader point here. I mean, this is essentially a social networking site. That's what gaming sites are. And I think access correction deletion rights, as opposed to portability rights, are different. Access correction and deletion rights are essentially reflecting the autonomy interests, the traditional data privacy interests of individuals in the controller's use of their data. Portability rights are different. They recognize what essentially is a sort of quasi-property interest in the data, the ability of somebody to move the data from one controller to another controller. And the use of those portability rights has an impact not just on the individual, but also on the transferor and the transferee controller, particularly in situations where the recipient controller might seek to incentivize the individual to do something that the individual would not have any personal interest in doing. And that through the use, for example, of sweepstakes entries or points and loyalty programs or some other method that has very little cost, by the way, to the recipient controller. So when you have that kind of incentivized portability, you have the potential for anti-competitive effects. I know that we've heard about the potentially competitive effects of recognizing a right of portability, and those may be particularly appropriate in social networking and gaming type situations. But in other situations where what might be ported, particularly on a mass basis, if somebody is incentivizing a whole group of people to do this portability, what you can get is access to what effectively is proprietary and potentially competitive information, pricing, quantity sold, the SKUs that are sold. And that sort of information, I think that you have the potential for entrenching dominant market participants if they can offensively use incentivized portability rights against their competitors. So I think if we look at portability rights, there is a valid justification for limiting them to a narrower scope than we have access correction and deletion rights to defeat that sort of incentivized portability and to defeat the potentially anti-competitive effects. So in this circumstance, this is effectively a social networking site. I think it's totally legitimate for somebody to say, I've contributed photographs or whatever you do. I don't do social networking, or I don't do gaming, but whatever you do on gaming sites that would be considered user-generated content, that may be perfectly appropriate that you'd be able to move that. But in other situations, we shouldn't mistake the potentially anti-competitive effects.
Can I just make one more quick point about the cheating? I think it's important to note that both, I know at least GDPR and FERPA distinguish when the individual has a right to correct their data. There's carve-outs for things like opinions, right? So I know ICO guidance has said, look at whether something's an underlying fact or whether it's an opinion about an individual, and opinions, there may be less of a right to correct that. Same with FERPA. It specifically says that the right to correct a student record, can't be used to challenge a grade, right? An opinion, a substantive decision made by a school. So I think it's important to have these boundaries in place when we're thinking about what exactly correction should reach.
Okay, well, these are obviously areas where you guys and many people here and online can talk about for a long time, but we have approximately 5 minutes left, so 1 minute each on your final thoughts of what we should take away from this, starting with Gus.
Okay. So I think that one of the key takeaways is that these rights serve to empower consumers, bring symmetry to the marketplace, make the marketplace more sustainable, bring consumers back in control with their personal data, enable watchdogs to protect consumers, to challenge the behavior of organizations, big and small, to question data hoarding, and at the same time, that we should be aware that in absence of a comprehensive privacy baseline and strong enforcement, it is unlikely that these rights on their own would have the effects that we expect them or we wish them to have. So we should think in context. Like as we were discussing all this panel, there are going to be cases in which these rights should be limited, and that's life.
Okay, we're going to have to pick up the pace.
Was I being told to talk faster? Because that is not something I struggle with. Actually, it's the one sort of point I wanted to add, and I agree with Gus, is that there, and I suppose as Google has sort of been a leader on some of these issues by the nature of the products we offer, I would just note that people do use these products. And sort of an interesting example is the ad settings. So every hour, every day, an average of 30,000 people are visiting Google's ad settings, and just under half of them are actually making changes, including correcting their interests. And I'm saying correcting because it's not a deletion, it's a correction. Might be learning you affirmatively don't want ads for this thing. And so it is something that I think it's easy to discuss in the abstract or in the concept of frameworks, but at the end of the day, really it's important to understand that people do use the tools that you build if you build them in a thoughtful way, and it does yield useful information for you, and if you're paying attention and you're learning from what's happening, right, you can improve things over time in a way that benefits everyone.
Just a couple points. I'll reiterate what I started with. I think context and reasonableness are kind of overarching principles that have to be applied here, and I think we've given lots of examples of that during our discussion. I think we're evolving, whether we intend to or not, and I think we should be more intentional about this to more industry or use specific kinds of guidance that actually accomplish something, as opposed to just putting an administrative burden on companies that really doesn't satisfy the objective that's intended. And while we didn't talk about it today, I just want to highlight it should never increase the security risks of an individual, however we go about trying to balance and maintain those.
This is a unique opportunity to empower consumers, to give them the information they want, to build new services, and to essentially create the framework we're going to be using for the data economy over the next several decades. Let's make it a broad, comprehensive right that serves consumers.
So I think it is a really important right and tool for consumers for transparency. And I think that we also need to include reasonableness and balance that needs to be balanced against the rights of other individuals, against needs from an organization to maintain data that are legitimate and good reasons to maintain data. So we need to factor all of that.
And I would say that these are important rights that in the business community we recognize that respect for customers' data privacy is an essential element of building customer trust, and that customer trust is the foundation of customer loyalty, which is essential to business success. I agree that these are very important rights and that they do require reasonableness and balance and a proper regulatory guidance and a time frame for complete implementation.
Great. And with that, a minute to spare, we will conclude the panel. Thank you, the panelists, for terrific thoughts and great conversation. And we will return at 1 p.m. After the lunch break with remarks by Commissioner Slaughter. Thank you.